Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers and the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Hi, Jacob Simon. I wanted to welcome you to the Divorce Planning Podcast and thank you for your time. I wanted you, if you don't mind, to discuss the class that you teach at MSU, Matrimonial Practice. It kind of was like a great outline of going through divorce from start to end. And I thought it would be kind of interesting if you would share kind of the tippy points of that class.
Yeah, absolutely. Well, first, thank you so much for having me today. When I'm not, obviously a full-time family law attorney, one of my little pet projects is in the fall semester every year. I teach a 3-credit course up in East Lansing at the Michigan State University College of Law called Matrimonial Practice. And it's a 3-credit-hour course where students get experiential learning credit while they kind of ride with me on this fun journey from initial client interviews all the way through writing up a final judgment of divorce and settlement agreements. And along the way, we look at everything first at a high level about what the law is on a subject, and then we kind of boil it all the way down to this fictitious Johnson case that we work on during the semester. And a couple times during the semester, once with custody and parenting time issues, and again with property division and support issues, I actually assign the students a partner, a co-counsel, to represent either Mr. or Mrs. Johnson, and then I make them go in class and duke it out with their opposing counsel. That's awesome. So this week couldn't have been a better time for you to bring me on your podcast because this class period that I just got back to the office from teaching up in East Lansing was the class period where I let the students duke it out and negotiate the property settlement and support awards. And it's a lot of work. And during the class, I also like to throw them some curveballs and remind them of things that they have to account for in dividing up the assets and liabilities that you wouldn't really think about just reading a textbook on how to go about their divorce case. And so if I could kind of maybe dive right into what that looks like, I told my students during the weeks leading up to this class period that we need to come up with a roughly equitable division of the marital estate. Equitable doesn't mean a perfect 50-50, but there's got to be a good reason to deviate from a 50-50 division of the marital estate. There's a key word right there, marital estate. Marital estate is all the assets and liabilities that came from the date of the wedding until, the date of the divorce kind of getting wrapped up and finalized. So anything that somebody had prior to the marriage is typically off the table. Assets that are gifted to one party but not the other during the marriage are typically off the table. And the appreciation on those gifted or inherited or separate property assets is typically off the table. But one interesting way in which an asset that maybe was premarital in a sense becomes marital can certainly be a marital home. Michigan has a court case called Cunningham versus Cunningham that stands for the position that in a long-term marriage, if you take separate property assets and contribute them to a marital home, it's considered a gift to the marital home. Now, what about a not marital home, like a cottage? Somebody inherits a cottage early on in the marriage and marital income is being used throughout the marriage to improve the cottage or maintain the cottage or help it keep its value or increase its value. Maybe that cottage now has a marital component to it, but it's not going to be treated quite the same way. Now, in contrast to Cunningham versus Cunningham, we do have Korth versus Korth, which had a short-term marriage and tries to rebut this idea that money from separate property being used to support a marital home is automatically marital in nature. But when you really start to think about it, the idea that it gets inextricably commingled from the marital estate makes a lot of sense because you're making property tax payments, mortgage payments, upkeep. Again, a home doesn't just magically maintain its value in a vacuum. There's a lot of upkeep. I mean, I'm a homeowner, Carri, you're a homeowner. Like it's a lot to maintain. So naturally, marital income, marital money is going towards its preservation.
I just want to like clarify this for people. Spouse A owns this cottage, premarital, using their own money that they earn to fix up and take care of this cottage. It's still marital because he earned this income while he's married, or not?
Yeah, maybe a portion of the cottage's value, right?
Okay.
Like, let's say, just to throw out some grandiose hypothetical numbers, let's say you inherit a little cottage in the middle of nowhere and it's worth $100,000. And you inherit this during your marriage, and income that you earn during your marriage by default, I mean, unless you got a prenup that says otherwise, income earned during the marriage is all marital property. So if you've got all this marital money being used to pay the property taxes, being used to make repairs, being used to maintain it, pay the utilities, all the things that it takes to just maintain that $100,000 in value, maybe some of that value has commingled its way into the marital estate. Or if it's gone up in value because you added a second floor or really, cleaned up the inside and redesigned it. Again, maybe that increase in value is marital property. So that's just something to kind of pay attention to and watch out for. But I think the bigger thing that my students were struggling with today, and as they got into their groups and were duking it out, is a last second private fact that we threw in to really make the negotiation spicy was we told all the attorneys representing Mrs. Johnson they absolutely had to get her the home. Okay. Under no circumstances were they to settle this case without getting her the home. Now, the Mr. Johnson people, we didn't tell him his side to necessarily get the home or necessarily cede the home or necessarily ask the home to be sold. But we just focused on the Mrs. Johnson people. Now, it was interesting to watch all these different groups. I got about 16 students. So, 4 groups of 2-on-2. And as I was kind of floating around the classroom today, watching the different groups handle the situation, I would try and make announcements to the class to remind them of things like, hey, students, don't forget when coming up with your final division of all the different assets and liabilities. There's the house, there's the cottage, there's the checking accounts and savings accounts and brokerage accounts and retirement accounts. Husband owns a business, vehicle, so on and so forth. Don't forget to make sure that your client has some cash on hand, because if you're representing Mrs. Johnson, well, she's got an attorney fee bill that's outstanding and needs to get paid. And if you're representing Mr. Johnson, he's about to be homeless. And so he better have, not only money to make, to pay his attorney fee and pay the mediation fee, but hey, he might need some money for a down payment on a home. And hey, Mrs. Johnson group, if you're awarding her the home, and you're also putting the mortgage in her column as well as an offset to the home, Mr. Johnson's name is on that mortgage, so she needs to refi the mortgage. Now, refi can be really helpful because if she needs more money to also, balance out the marital estate and put cash in her pocket, that's great. But how much of a mortgage does she pay? Can she afford? How much equity is available in the home for her to take out? How much mortgage can she qualify for based upon her income, child support, spousal support? I wasn't necessarily giving them the answer to these questions, but I wanted to see the gears start turning in their heads, that this isn't as simple as, okay, wife, Mrs. Johnson's keeping the house and of course the mortgage with it. She's keeping her cars, and let's just put enough other assets in husband's column to offset. It's not that simple, because we have to set our clients up for success going forward. If she's going to do this, does she have enough cash on hand where refining doesn't put her in an impossible position? And, does the Mrs. Johnson attorneys need to go out in the hall and have a conversation with their fictitious client, who this week was played by my colleague, Erica Brown at Bank Rifkin? They need to have a conversation with her out in the hall and say, hey, Mrs. Johnson, maybe you should start working with somebody to one, see if you can qualify for the mortgage necessary for this home, and two, maybe this is a lot of home. And what's very common in my practice is that if you've got a couple that's just barely financially making it in their really nice big home with their kids and everything else, chances are they can't make it in two homes on that same income. It's not like the government is helping them and giving them more money by way of being divorced. If anything, especially if there's a disproportionate earning, going from married filing joint taxes to two single people taxes probably means that we're increasing the amount of income tax they're paying and not decreasing, because that married filing joint brackets are really nice when you have a really high income earner and a low income earner combining for a lower overall tax obligation than two single filers. So if anything, instead of one home, two homes, instead of married filing joint taxes, two single filer taxes. So if they're just barely making it in that one home together, chances are there's no way they're going to afford to keep Mrs. Johnson in that home, afford for her to refi and all the other stuff. So that means the attorneys need to start having a very difficult conversation. And it's the difficult conversation is with the client, not the opposing counsel. And that's one of the other big takeaways for the students. And they don't learn that the easy way. They learn it the hard way.
Right, that's true. And then also when the couple is, when they purchased this home, it was probably a couple of years ago at least, right?
Mhm.
So prices were less, property taxes were less.
Yeah.
Right now, interest rates were less.
Oh.
So to even take that large home and turn it into two little homes, it's not even like I have a $400,000 house, so I can do two $200,000 house. It doesn't even work, because when they purchased it, things were so different. And then you have that property tax cap, which messes a lot of people up too. So you stay in your current primary home and your property taxes are capped, so they're still lower. And then you go to move into new home, and now that property tax cap goes away. So now you're paying a higher property tax that might even be more than your current tax, even though it's a lower home. So it gets super confusing.
Absolutely. And this is where it becomes the most difficult for my students. And again, I'm talking about second and third year law students. I'm talking about people who are 1-2 years away from being full-blown lawyers. And this is really tough stuff for them to wrap their heads around. And as they're struggling with it, and I see the gears turning and they're learning about it, I like to turn to them and say, hey, guess what? In a couple more years, you're going to have to be the ones teaching this to your client. So
Right.
you better get real familiar real fast, and or make sure you're talking to the right people to help you along the way. Google can only take you so far. And, lawyers are all, especially family law lawyers, are phenomenal Googlers, right? Because we're wearing so many hats. Like I tell my students on day one, to do this job, you got to be a CPA, a business evaluator, a child psychologist, amongst various other things. But the reality is, we Google and research on our own as much as we can to try and fill in some of these blanks. But then we need to early and often find the right experts to assist us with our case. And so, Carri, one thing that I love about working with you is, obviously you always realize that no matter how early we're bringing you in, we need to be bringing you in even sooner. But the fact of the matter is, you can also assist us with that difficult conversation. You can sit down with us and Mrs. Johnson and say, look, Mrs. Johnson, technically, you might be able to keep this home, right? Your combined expected child and spousal support will be enough for you to qualify for the mortgage. Not only the mortgage that it'll take to refi the home to get husband's name off of the mortgage and buy him out of the portion of the mortgage that's outstanding, but also the fact that you need to give him the half net equity, right? The house was bought for 4. They put down okay, let's say the house was 500,000. They put 100,000 down payment. They've owned it for a few years, but now the house is worth 6. Well, now, the mortgage was maybe paid down 20,000. So there's an 80,000 mortgage against a $600,000 home. There's now $520,000 of net equity, half of what, so they owe 380, but on 6, that means that net equity is now 220. And so she has to be able to get a mortgage to cover the outstanding 380 owed on it, plus giving husband half of that net equity. I mean,
And
is there enough?
closing costs and escrow account.
Right. Is there enough equity in the home to afford that? And even if there is, that's going to be a very different mortgage than 3 years ago. One, because of interest rates. Two, because of uncapping the taxes. And three, because the house appreciated in value, and you owe husband half of that appreciation in addition to half of whatever net equity you already had in it anyway by way of paying down the mortgage and your down payment.
Right. So they're borrowing, she's borrowing way more than what they borrowed together.
Yeah.
Yeah, it gets very tricky. And there's a lot of conversation about, and this is a good thing for you to talk about too, switching assets. Like, even though everything isn't created equal, but sometimes we have to bring up what other asset can you give up so you don't have to tap into so much equity of your home. Yeah. Because you're not going to be able to keep the house if you have to finance so much more money.
Yeah. And so one thing I was exploring with my students was, well, if Mrs. Johnson makes a lot less income, taxable income than Mr. Johnson, well, her child support payments, that's not taxable income. It may be income for mortgage securing purposes, but the IRS isn't taxing you on it. Similarly, the IRS isn't taxing you on alimony. There are alimony awards from prior to January 1st, 2019 that are taxable as income and deductible to the payor. But the current alimony awards being given out right now, or being awarded right now, are not taxable to the recipient and are not tax deductible to the payor. So if wife receives child support, spousal support, and has a very modest income, and wife wants to tap retirement dollars, now she's less than 55 and a half, there's a 10% penalty. But if you are taking out cash from the other side's employer-provided retirement account pursuant to a qualified domestic relations order, then Internal Revenue Code Section 72, subsection T says that you can waive the 10% penalty incident to that quadro. And so, again, income taxes, at least at the federal level, are bracketed, right? You're taxed 0% on so much income, and then you're taxed like 8% on so much income, 10% on so much income, and the brackets get bigger, and you're taxed on like the additional amount. So it's not like, oh, because you made, $100,000, all of your income is taxed at 22%. No, out of my $100,000 income, the first 6,000 was zero, and then the next, 20,000 was taxed at 10%, and then the next chunk was taxed at a different percent. So if she has very little taxable income, and she takes a rollover from his 401k and has it turned into cash, she avoids the 10% penalty pursuant to IRC 72T, and she probably doesn't pay a lot of income tax on it if she doesn't have a lot of taxable income for that year. So it may make very good financial sense for us to quadro over some of husband's 401k to wife to create some more cash available, both in terms of cash that she can give right back to husband to help buy him out of his interest in the home, reducing the size of the mortgage that she needs to take out, but also maybe to create some cash for her to pay those closing cost commission fees, or cash to help jumpstart her on making those first few mortgage payments. And the important thing to remember is technically you can, in the same quadro, you can send some money to cash and the rest to be rolled over into an IRA to, save for Mrs. Johnson's retirement. Sometimes I do like to use two different quadros, even on the same account, one quadro just for the cash out, and another quadro for the rollover. And the reason why I'll do this is because sometimes we want to access that cash during the divorce case. Not all lawyers seem to remember sometimes that you can do a quadro at any time. You don't have to have the quadro happen after the judgment. You can do a pre-judgment quadro to get some cash in the party's hands. And again, this is a great way to plan things ahead and set parties up on the right track for their post-divorce lifestyle. And, this circles back, of course, to Carri, why it's so important to bring you in early, is that even if it's not going to be possible for Mrs. Johnson to keep the house, because let's say it's maybe technically she can, but it's just not a good fit. And that's another thing I try to drive home in today's lecture, that I want the students to realize on their own that, wait a minute, we're putting just the house in her column, and husband's going to walk away with all the accounts and everything, and because of the buyout necessary, and she's going to be strapped with this huge mortgage that's going to eat up almost all of her alimony. This is a bad idea. And so, Carri, that's another reason why bringing you in early and often helps, because you can realize that and see that 10 steps ahead. And instead of focusing on how do we refi to keep the home, you can start having that difficult conversation with the client about, okay, well, what can you qualify for and what makes a lot more sense to set you up for financial success going forward. And then that way we've got our ducks in a row going into mediation where Mrs. Johnson already knows, okay, I'm not going to try and keep the house. I'm going to start shopping around for other houses in a different price range. And that way she's out house shopping before marital home ever gets listed up for sale. That should give her plenty of time to buy a home that's hopefully nearby, keeps the kids in the same school district, keeps her, regular routine intact, and hopefully right sizes the house for her budget going forward.
So true. You'll appreciate this. I was referred someone the other day to talk about refinancing and keeping the house. And she called about, I don't know, a week before their mediation.
Oh no.
And so I'm talking to her and I'm going through all the numbers with her. And she's like, I don't want to pay that for a house payment. I'm like, okay, I don't blame you. So let's talk about if, you put the house up for sale, or if your husband keeps the house and buys you out, what does it look like to buy and pay off debt? What does it look like to buy and not pay off debt? And, kind of work through all these numbers. But here she talked to her attorney, paid, hourly fee over and over and over, setting up all this negotiation to keep the house. And then realized a week before that she really didn't want the house, but she didn't go over the numbers before. So yeah, she called me last night, even in hysterics, like, my attorney brought this up with me sooner. Why did I talk to you so late? I don't know what I'm going to do. Yeah, so it is interesting that sometimes you do get so focused on dividing assets that you forget there's life there, right? So it's good that you bring that up with your students. I wanted to ask you about something else too, because interest rates are so much higher than they were at the beginning of the year, and most people have mortgages in the 3% range. I see a lot of cases where they say, let's not refinance the house. Let's keep the current mortgage. Let whoever's going to stay there stay in the house and make the mortgage payment, and we'll refinance down the road. And even though I know money-wise, that might sound like a brilliant idea, but there's obviously very high consequences doing something like that. Can you talk about that a little bit?
Oh yeah, I would never, ever want to let my client walk away from mediation saying, oh yeah, we'll just let the other side live in the house and pay the mortgage. I mean, 3 things jump right out at me. Number 1, your credit score is tied to that mortgage. Which means, first of all, good luck qualifying for another mortgage, because they're going to see on your credit score that you already have a mortgage on this house. So good luck qualifying for your own house if you want to buy your own house after the divorce is over. Tied into credit score, if the other party is the one that's on the house and they fail to make a mortgage payment, guess whose credit score is getting hit? Both of them. Okay. So this leads me into point number 2, which is, banks don't care what your divorce judgment says. Okay, this is same not just for homes, but this should be on your radar for homes, for cars, for credit cards, for personal loans. Just because your judgment of divorce says that, husband's going to pay off the credit card and the personal loan and the house mortgage and this and that, and hold the other side harmless and indemnify and defend, the bank doesn't care. The bank's still going to foreclose. The bank is still going to take the collateral back. The bank is still going to tank your credit score for non-payment. So that's incredibly, incredibly risky. And the third and final thing that I'll say about this is that it goes against everything that we strive for, at least, myself and most of my colleagues who I feel like practice at a high level, which is creating finality as much as possible for the parties. I mean, there's certain things that are inevitable, right? Parenting time schedules, so co-parents are going to have to interact with each other, and that's fine and good. And support awards, again, especially child support, nothing you can do there. Alimony might be able to do a buyout and to get the parties, as separate as possible. But on the property settlement, maybe a couple of very rare circumstances that I'll segue to in a second, you gotta get them finality ASAP on the property settlement. I mean, the one and only thing that I'll say about property settlement is in some of my cases over the years, and this is usually more so with businesses that are owned by a spouse rather than houses, but I suppose it could apply to houses too. Maybe we'll say, look, there's this big fat buyout number. Nobody has the money to pay it right now. And, maybe mortgage rates are really high, so we don't want to take out a mortgage. So let's just say that this big fat buyout number is going to be made in increments over the next few years. And to be fair to the side receiving it, it's not going to be an interest-free loan for the side who owes it. Maybe we can put together some interest. Maybe we can ask Carri to help us with putting together an amortization schedule so that everyone can see what the buyout value of it is now in case the paying party comes into some more money. But we need finality. So again, number one point is credit score. It's going to stop the other party from being able to qualify for their own mortgage going forward. Point number two is the banks don't care, so they're also going to tank your credit score and go after you for unpaid mortgage. They're going to foreclose on the home, and if the foreclosure sale doesn't cover the outstanding mortgage, they're going after the parties joint and severably, which is legalese for the bank's going to go after whomever they think they can get the money from.
Right, for sure. And then I've heard from bankruptcy attorneys that if the mortgage is in both names, or the note, I should say, really is in both names, and one person files bankruptcy, then the other party is stuck with 100%.
Yeah, so that's a whole nother issue. If both names are still on the mortgage, then the mortgage company is not going to let you retitle the asset. So let's say it was purchased during a marriage, it's tenancy by the entireties, and the spouse who's keeping it wants the other spouse to execute a quitclaim deed, conveying all of their interest to the party who's keeping the home going forward. Well, the mortgage company is not going to allow that quitclaim deed to be recorded if there is still a balance on the mortgage owed that the other party is still tied to. And that means that going forward, that house is still half the asset of the other party, which means that the other party is going through things. And again, just because it's titled entirety's property, well, because you're now divorced, as a matter of law, it can't be entirety's property anymore. So now you're tenants in common.
Right.
And as tenants in common, let's say Mrs. Johnson keeps the home and Mr. Johnson goes out and does a really bad thing. I don't know. You insert the bad scenario. I don't want to be responsible for that, but he does a really bad thing and he gets sued and his insurance doesn't cover it. And now his judgment creditors are coming after him for all he's got, right? They can go to court to have his portion of the home levied for his debt, okay? And then they can take that judgment debt and cause a foreclosure sale. Or if he's going through bankruptcy, the bankruptcy trustee, again, can consider half the home to be his. Again, the bankruptcy court or the debtor's court or wherever, nobody cares what your judgment of divorce says, okay? As far as they're concerned, he's legally titled on that home and, he's legally titled on that mortgage. That's all they care about.
And a lot of people don't think about that. I have people being suggested that all the time. And then I don't know about, I can't speak for any other mortgage company. The one that I work for is really, really divorce friendly. And if someone's divorce decree says that their spouse was awarded the home and 100% responsible for that debt, we will not count that as a debt when qualifying them for a new home. So I know you have to talk broader strokes, but I
yeah, absolutely.
Get my own little plug in there.
Well, that's fantastic, and I'm so glad that your company does that. And I wish all of them did, but I can't bank on that when I'm advising my clients because the law doesn't require mortgage lenders and banks to do that. So that's fantastic though that yours does.
Yeah, it's nice.
Carri, I've got a question for you, and this is coming up a lot right now in my cases because of the new high interest rates and the old low interest rates that the mortgages already are. Under what circumstances are you seeing people going through divorce able to successfully use an assumption?
I knew that. I knew that was going to be your question. So there's two types of assumptions, which a lot of people don't understand either, and a lot of attorneys don't understand. So you have your simple assumption and you have your qualified assumption. So Garmin St. Germain Act or whatever that is, that says upon death or divorce, you can assume the mortgage. So that's the simple assumption. So if you and I are married, we own this house together, we get divorced, I'm gonna stay in the house, but the mortgage note was only in your name. So whenever I call that mortgage company, they never talk to me. They don't, tell me what's happening with taxes getting paid. I have a question about something. So I could, according to that St. Germain Act, I could write them a letter and say, look, I'm divorced. I was awarded the home and I'm now assuming that mortgage. And now they have to talk to me. But that's all that assumption does, is give me permission to get information. So if your judgment says you have to assume the mortgage, well, I assume the mortgage, but I didn't relieve anyone of liability from that assumption. So that's called a qualified assumption. So most government secured loans, so the FHA loans, the VA loans, those are usually always assumable. Now, someone who's not a veteran can't assume a VA loan. That can't happen. And usually if you're taking money out of the mortgage to do the equity buyout or pay off a home equity loan, then those are usually not allowed in an assumption. But you could do the qualified assumption. So basically, whoever has your current mortgage calls the person who wants to assume, and they go through what's your income, what's your asset, what's your debt, let me run credit. It's basically starting all over, but you don't usually pay like closing costs and those kind of things. And then they allow you to assume the mortgage solely in your name. So they're basically taking that mortgage note and stamping it paid in full. And they're having you sign a new mortgage note and they're recording a new mortgage. So they're discharging the mortgage that you and your spouse are on, and you're signing a new mortgage with just your name. So rarely, but I have recently seen, even on conventional mortgages, where some loans are doing the qualified assumption. A lot of places are not, because they're now loaning out on CDs and everything else, interest rates in the 5s, right? And you're trying to assume your 3% loan, and the bank's saying, that doesn't really make such great business sense to us. So sometimes they'll say, you can assume, but we're going to raise your interest rate. Or you can assume, but I want another $50,000 from you, so you're paying less. So sometimes they're coming up with these very funky things, and every single institution is very different. And you can only go to the institution that you're currently making your mortgage payments to. But I'm glad you asked, because that whole assumption thing gets super confusing, just like how you and I talk, and we always say the mortgage, the mortgage, the mortgage, because that's like our professional language, right? But in all reality, we're talking about the promissory note. And that gets confusing too. So to the layman listening, we say mortgage, but we really mean the mortgage as a whole, not the physical piece of paper, the mortgage. So that's another thing that always gets tongue-tied.
Yeah, because the mortgage is the recordable instrument with the register of deeds. The note is the actual loan that you signed with the bank and agreed to make payments on.
Right. We always call it the mortgage, right? We always say that.
Yep.
You are always a wealth of information, Jacob. And I could do like a million podcasts with you, because your office and working with Susan, and it's you guys are just so phenomenal and so smart. And the fact that you come off with all this off the top of your head is unbelievable to me. Thank you so much for the time that you gave me. I really appreciate it. How can someone reach you if they want to get a hold of you?
Yeah, one of the best ways is to give a call here at the office, 248-644-5600. And you know what? If you even want to send me an email instead, Jacob, JACOB, at SusanECohenLaw.com. That's SusaneCohenlaw and you can always Google me, and I'm sure my MSU adjunct professor webpage pops up, my Susan Cohn website pops up, my ICLE speaker website pops up, amongst other things. Like I'm in Super Lawyers and a bunch of other directories, so I'm not too hard to find. There is another Jacob Simon in the State Bar of Michigan. I know him. He does I think employment and labor law, so we're not in competition with each other. But
Thank goodness.
yes, but I'm the Jacob Simon that's a redhead.
There you go. I know, and I want to sit in on your law class. I think that
Yeah,
sounds so fun. I
absolutely.
really definitely want information to come visit.
Yeah, I love teaching. I feel like it's one of my special skills as a divorce lawyer, is being able to break it down to my clients the same way that I have to break it down to my students. Because at the end of the day, no one's going to feel satisfied or happy with the result of the case unless they understand it. And Carrie, that's a big part of what bringing you into my cases is so helpful on, because there's a limit to my level of expertise when it comes to mortgages and how all these different instruments work. And obviously, I have a very rough estimate as to what a party can afford going forward, and on their budget and on their support awards. So it's always a pleasure to work with you and have you involved.